Do you think you have a simple, uncontested divorce? People come to me all the time saying this. Then as soon as their spouse gets the letter, all hell breaks loose. That's because it doesn't take a lot to turn an uncontested divorce into a contested one. All it takes is a little uncertainty mixed with a little bit of miscommunication and boom, that simple uncontested divorce blows up. So in this video, I'm going to show you 5 red flags that derail cases, 2 habit systems that prevents them, and rescue plans for when things start to get off track. I'm Vanessa Vasquez de Lara, founder of the Vasquez de Lara Law Group. It's our mission to make lives better in and out of family court. My team and I have handled thousands of divorces, both contested and uncontested, and we know the warning signs. You should too, because if you want an uncontested divorce to stay uncontested in Florida, you'll need to see the small bumps in the road before they get here. A fuzzy parenting plan, a bank statement that never arrives, a deadline that keeps moving. These small things repeated over weeks turn an agreement into an argument. And so there's no miscommunication here. This is general information for Florida divorces. For advice on your exact situation, talk with a Florida family law attorney, like one on my team. The 5 red flags. Now, what surprises a lot of people is it's usually not a big fight that derails uncontested cases. It's usually a few small things people think they can figure out later. But when that time actually comes, they realize that there was a lot more disagreement than they thought. Then someone files a petition for divorce with all of their demands, and the other party is backed into a corner with their response and counter petition. Now we have a long, drawn-out, and expensive contested divorce. So let me walk you through some red flags and the quick fixes that could keep your uncontested divorce on track. Red flag number 1, a vague parenting plan. You hear, we both want 50-50, we'll figure it out. But 50-50 is a slogan. It is not a schedule. In Florida, what people call custody is actually 2 things. Time sharing is a schedule for when the child is with each parent. Parental responsibility is who makes major decisions. When the plan is vague, pickups get missed, feelings get hot, and someone says, I'm going to see you in court. The fix? Put that plan into practice as soon as possible and stick to it. Write the whole month schedule out in advance with exchange times and locations. Add in the holiday schedule. Add parental responsibility rules in plain English and decide how you are going to settle disagreements without going to court. Red flag number 2 is where most cases stall. Asset anxiety. In a lot of uncontested cases, both spouses agree to keep the assets and debts in their names. So what happens with the house? Most likely it's going to be sold, but that could take months. Who's going to accept an offer? What if one of you wants to hold out for more? And if one of you does want to keep it, you're going to have to refinance it to take the other one off of the mortgage. But what if you can't get approved? That's where things start getting messy. To avoid this, agree to a plan now. Get a neutral appraiser to give you a valuation and decide on a number you'll accept. Then set a deadline with step downs and price you'll accept. If you're going to try to refinance, set a deadline for that to happen. If you can't get an approval that will give you the cash to buy the other one out by a specific date, you'll put it on the market. Now, red flag number 3, disclosure, shortcuts, and deadline drift. In Florida, you technically don't have to do a financial affidavit for an uncontested divorce, but I highly recommend that you get full financial disclosure so you have everything on the table. Those lingering questions can quickly burn whatever trust you may have left, and set a clear deadline to get all of your finances in the open. You may not have been able to agree on things before, but sticking to this one can literally save you tens of thousands of dollars in a contested divorce down the road. Red flag number 4, outside voices. When people find out you're getting a divorce, everyone is going to have an opinion. Friends, new partners, and social media experts can pour gas on small issues. You hear, my friend got X, or this guy on TikTok says Y. This is one of the biggest reasons I recommend that you have an attorney represent you, even in an uncontested divorce. A good attorney, like one on my team, can help you compare your options and what each could cost you in real time and money, instead of just your pride and ego. And red flag number 5, text wars and tone traps. All all caps, sarcasm, text to turn into 10-paragraph essays that will for sure be saved in a screenshot. Even in an uncontested divorce, tensions run high. So keep your text messages short, factual, and to the point. No labels, no accusations, and no blame. And if you get one that does trigger an emotional spike, don't respond right away. That one amazing comeback is not going to be worth a year-long court battle when you could have taken care of this in a couple of months. Now, the real key to keeping an uncontested divorce on track is momentum. But momentum isn't a mood. Momentum is a system. So here are 2 habits that can keep an uncontested case from going off the rails. Habit number 1, put dates on everything. Dates turn vague hopes into clear next steps. To make an uncontested divorce work, you need to agree on everything before you file. That means you lay out a plan with deadlines. Figuring out your parenting plan, put a date on it. Taking the required parenting class, put a date on it. Getting an appraisal on your house, put a date on it. You get the idea. When you set clear deadlines on the steps and agreements you need to make, your divorce could be finalized in a matter of weeks instead of dragging on for over a year. Habit number 2, name tiebreakers now. Don't wait to pick a neutral party when you're upset. Agree on an appraiser for the house. Agree that a pediatrician can break disagreements on health choices. If you decide on your neutrals now, in a dispute you can't settle shows up, you won't lose a week choosing who decides, or worse, waiting for a judge. And the other great thing about picking neutrals, somehow, magically, when you both know someone else will have the final say, it can make you both far more reasonable and willing to listen. So what do you do if things do start going off the tracks? Here's a few ways you can rescue your uncontested case before it turns into a contested one. Rescue number 1, a single issue sprint. Book an hour meeting or call this week to bank one easy win. Don't try to solve everything at once. Pick the holiday schedule. Pick the appraisal date. Pick the daycare drop-off plan. Whatever it is, focus on that one thing to come to a single agreement. Wins create momentum, and momentum can carry you to the next win. Rescue number 2, let your lawyer handle it. If things get really heated, remove yourself from the situation and let your lawyer know. Sometimes a quick communication from your lawyer can help the other side keep things in perspective and realize if they're being unreasonable. And rescue number 3, a collaborative pivot. If there's something that you just can't agree on your own, you don't have to file a contested divorce right away. The collaborative divorce process can still be an option, especially if privacy matters to you, as long as you're both still willing to share information and come to the table in good faith. The collaborative process can help you work through your differences without a judge. You'll both sign a simple agreement to stay out of court. You'll each have your own attorney to represent your best interests. Then we get a neutral facilitator to run calm meetings and a neutral financial professional to gather your documents and give us some options for dividing the assets and the debts. Most collaborative cases finish in 3 to 6 months, in 3 to 6 meetings. When it's all done, we'll have a signed marital settlement agreement, and then we file it in court, just like an uncontested case. You don't have to do it alone, and it can often be done in a fraction of the time and for a fraction of the cost of a contested case. So let's recap. If you're planning on an uncontested divorce, you want to keep that train on the tracks. But the things that turn uncontested divorces into contested battles are often uncertainty and misunderstanding. We covered 5 red flags and ways to handle them: vague parenting plans, asset anxiety, disclosure shortcuts and deadline drift, outside voices, and texting wars. I gave you 2 habits to give your case the momentum to stay on course: putting dates on everything and naming your neutrals now. And finally, we went over 3 ways to rescue an uncontested case before it turns into a contested one: a single issue sprint, letting your lawyer handle it, and a collaborative pivot. With these tools and some good counsel from an attorney, there's never any guarantees your case will stay uncontested, but you're much more likely to keep it out of court. Now, we covered several red flags, but there are a lot of other considerations you need to make before moving forward with a divorce, especially if you want to come to an agreement early and go the uncontested route. So before you decide anything else, take my divorce readiness quiz. It's free, it's private, and takes about 3 minutes. It will take you through a lot of the considerations people never think about until you're in the middle of a court case. And if you've already reached an agreement with your spouse and want a lawyer to review it, call my Miami office for a free case evaluation or schedule one on our website. We'll look at your facts and give you the next steps. And in my next video, I may just give you a little bit more motivation to stay on the uncontested path. We're going to talk about the hidden costs of contested divorce, not just fees, the non-court costs to both your bank account and your life. These are the things a lot of people will never tell you about. Until then, I'm Vanessa Vasquez de Lara, founder of the Vasquez de Lara Law Group, where we make lives better in and out of family court. See you soon.